afternoon, everybody. Let's see if we can get you over the post-food slump with some discussion of corruption. I have a very esteemed panel, but I won't go through all their details because, as you already know, there are some materials available on our website, and that includes all their details. But just to introduce you, put a face to relevant names. Starting from your left, so closest to me, we have Khurram, who's an Addelshaw Goddard based in Dubai. Beside him, we have Emilie Gonin, who's as barrister in Doughty Street Chambers in London. Then next we have Stephen Osuhar, who's at driver Trett, so providing expert services based in Dubai. Next to him, Mark McNeill at a well-known law firm, Quinn, who was based in London for a number of years and has now just moved back to New York. And then somewhere way in the distance we have, I can't quite see him there, yes there he is, Imad, who's at Winston and Strawn and based in the United States. So we're going to try to, number one, be the first panel that keeps to time. Number two, even do better than that, reduce the time we take. And even if you learn nothing about corruption, we will regard ourselves as having fulfilled our mission if we do those two things. But insofar as we can tell you a little bit about corruption, we will give you a whirlwind tour, both corruption as it applies to investment arbitration and corruption as it applies to international commercial arbitration, and if there are any distinctions between the two which you need to know about. I remind myself that the general topic, the general theme of our conference here today is international arbitration in Pakistan. And corruption, of course, is not confined to any particular country or any particular culture, but for better or for worse, some cases involving Pakistan have involved allegations of corruption. I've done two investment arbitrations involving Pakistan, Agility and CIICA. Both of those involved allegations of corruption, usually corruption alleged in the making of the investment, so as to deny protection. But equally, corruption allegations can apply in the context of generic commercial relationships arising out of a contract. And corruption is usually of some interest to us lawyers, not really for the legal consequences, but it gives us the chance to believe that we're living in some sort of American lawyer movie where things are very dramatic and we're being detectives investigating the documents and putting all the pieces together, and we have a big board and we connect all the dots. And that's why, just as a general lawyer matter, corruption is of some interest to us. It obviously has very important legal consequences. So what I'm going to do is invite various members of the panel to address particular topics, and I will be a moderator, guide through this topic. And I'm going to start with Emilie and ask her if she could just tell us a little bit about what we mean by corruption in the context of international arbitration, because it could mean many different things to different people. And so what are we talking about?
Thank you for the introduction. There is, from a conceptual perspective, first of all, a tension between what arbitration, international arbitration is, and bribery and corruption on the other side. Now, why is that? International arbitration, be it investment treaty or commercial arbitration, arises out of parties' consent to it, out of parties' autonomy. And the tribunals only have the jurisdiction that is granted to them by the parties. On the other hand, bribery and corruption are public policy issues. They are criminal offences in most of the jurisdiction in the world, and they are also combated by a number of agreements at the international level. And so there is a tension when we talk about bribery and corruption within the context of international arbitration, because of the very specific nature of what international arbitration is. Now, when does it arises, and I think that's what was meant by Corbett, what are we talking about? And I think the best way is to introduce you to that is to discuss the cases in which it may typically arise. So first of all, in both commercial and investment treaty arbitration, it can arise, it often arises as a defense that is being raised more often than not by the state party. And so what is it in commercial arbitration? The state party would argue that an obligation under the contract that the contract is not valid and it doesn't have to fulfill its obligation because the contract was procured by fraud or corruption. So that's one case where it often arises. In the context of investment treaty arbitration, it arises where the state argues that the tribunal has no jurisdiction because the investment was procured by corruption, for instance, but also it can be raised by the state not to have to abide by the obligation under the treaty because during the performance of the investment there were some facts of corruption or bribery. So first situation effectively is a situation where it is a state defense to an obligation under the contract or under the treaty. Now, second type of situation where it may arise, it could be part of the narrative that is put forward by the other side. And that can happen typically also in investment treaty cases, not alleged by the state, but alleged by the investor. What the investor says is, they have been criminal proceedings, for instance, that have been set up so that my investment is being confiscated as a result of fraud allegations that are unfounded. So the criminal proceedings are a tool to confiscate the investment. And that is being argued more and more, in particular in the context of the arbitrations that have arisen in the Turkish context, in the Goninist context, where criminal proceedings have been commenced by Turkey to confiscate assets through ancillary civil proceedings. So criminal proceedings arise, person is corrupt, and then the investment is taken and goes back to the state as a result of the alleged corruption against the investor. Now, finally, unfortunately, more rarely, corruption can be invoked to challenge awards, and it can be invoked that the award was procured by corruption through corrupt arbitrators. And we were all discussing the other day. There is at the moment in Peru 17 arbitrators or 14 arbitrators that are in prison. They're in pre-trial detention because they have been accused of corruption. In 42 arbitrations. So there were 42 arbitrations brought by a Brazilian company against Peru, most of which were lost by the state, and now there are 14 arbitrators that are in prison. So that is typically the situations in which it arises. I think that I wanted to give you just one example of a case which is the most famous case in terms of corruption and arbitration. It's World Duty Free versus Kenya. Most of you will be very familiar with it. What happened there is that the tribunal found that it had jurisdiction, but that the claim was inadmissible, and that the contract that was underlying the investment was invalid because the investor had paid a $2 million bribe to the then President of Kenya to procure the contract. So that is the sort of quintessential example of what we are talking about.
So I'm going to invite Mark and Imad to sort of elaborate on this. And in particular, can you focus on the distinction of the application of corruption in an investment arbitration context and an international commercial arbitration context? So maybe starting with Mark.
Thank you, Paul, and good afternoon, everyone. It seems like everywhere we look today, we see corruption. And there's a joke in North America. I look at the government south of the border, and all I see is chaos and corruption. Thank God I live in Canada. And corruption now becomes a feature in so many arbitrations. It's almost a knee-jerk reaction in investment treaty cases. But it is remarkable how different the approach is of tribunals when you look at the difference between commercial cases and investment treaty cases. So starting with the commercial treaty world, the predominant way a tribunal deals with corruption these days is by applying the doctrine of severability. And we heard our illustrious keynote speaker discuss the doctrine of severability in the context of Pakistan. And it is a feature of many major legal systems around the world. You see it in Section 7 of the English Arbitration Act. You see it in Article 7 of the Untitled Model Law. And it allows the tribunal to say that even if the contract at issue is void for corruption, for fraud, misrepresentation, then the arbitration clause will be treated as presumptively valid. I say presumptively because it is technically possible for the parties to negotiate around that, but it's extremely rare. So there's an allegation that the contract is procured by fraud. The contract itself is declared void, but the arbitration clause survives. And this allows the tribunal to treat corruption as a matter of merits, right? Not jurisdiction or admissibility, but merits. And I think the advantage in that context is that the tribunal can now look at both sides of the equation. Very often when you're talking about corruption, there's a bribe giver and a bribe taker. And you can look at both sides and decide who is perhaps more liable. And you have a toolkit of ways of dealing with corruption in the context of merits, right? You can either adjust the claims, you can adjust the quantum of damages, but you can take and the tribunal can, on its own initiative, order document production and pursue that issue and reach a satisfactory conclusion. There could possibly be an issue of choice of law. There's a case in the English High Courts in which the Iranian National Oil Company asserted that the contract at issue was seeking to set aside the award, and it said the contract should have been governed by Iranian law, which doesn't recognize the doctrine of severability. They lost that argument, but it does raise the point that there could be an issue of the applicable law. You could have an applicable law that doesn't apply it, but the overwhelming dominant feature, way in which corruption is handled by commercial arbitral tribunals is to determine the corruption issue arbitrable, to determine that the arbitration clause is severable, and to take cognizance of that issue and rule on it as an issue of merits. Now, skipping to investment treaty arbitration, and Emilie already touched on this in discussing world duty free and so forth. It's really much more of a binary issue, so that if the tribunal does not find any corruption, then the claims go forward. But if the tribunal finds that there has been corruption in the making or the procurement of the investment, then generally speaking, the claim is dismissed as a matter of jurisdiction or admissibility. And I'll let Imad elaborate on the fine distinctions between those two things, but the essence of it is that the claimant is deprived of its claim. This leaves the parties in a situation where, in some cases, the tribunal is conflicted because the state, because it is also engaged in many cases in some act of corruption, such as in World Duty Free, was the former president, which had taken the $2 million bribe, but then the state is immune from a claim under an investment treaty. It says, we'll come to our courts and do the best you can, but they're immune from an investment treaty. So it seems to be in tension, at least to some extent, with the principle that a party should not benefit from its own wrongdoing. So sometimes in investment treaty cases, it's a less satisfactory solution in my view, because it is binary, and the tools that the tribunal has to deal with it are sometimes quite crude and result in unfair consequences. So I'll leave off there and pass to Imad.
Thank you. So I certainly agree that there are at least some differences between how corruption is treated and handled in commercial arbitration versus investment arbitration. And I'll flag post two: one legal consideration that plays a role, and a practical consideration that also plays a role when you raise corruption arguments. Picking up on what Mark had said about how commercial arbitration and investment arbitration tribunals deal with corruption, as he stated, more often than not in a commercial arbitration sphere, the issues of corruption, illegality are dealt with in the merit side of the face. They're not issues that come up with regards to the jurisdiction of the tribunal itself. However, unlike in commercial contexts, in investment arbitration, very often the issue of whether corruption had occurred occurs in the jurisdictional phase of the arbitration itself, and so tribunals have to deal with it rather early on rather than later during the merits phase. There's very good reason for why this occurs, right? For those, and some of you may already know, the underlying sort of legal regime that gives rise to this difference in the treatment of corruption in the jurisdictional versus the merits phase, and that is this, that in the investment treaty regime, what is protected is, quote, an investment. You can bring claims against the state for violations against, quote, an investment. Investment is a defined term, and to have a foreign investment in a country, the argument is that it must have been made lawfully. So if the investment is not made from the inception in a lawful manner, or if it is tainted by corruption or illegality in any way, then guess what? You do not have what is called, quote, an investment. And if you do not have an investment, then none of the rights of the treaty apply, and the jurisdiction of the tribunal does not exist because there is no investment at all from the very beginning. So that's sort of the fine distinction regarding why it makes sense that in an investment context, we're dealing with illegality and corruption from an earlier point on if the inception was tainted by illegality. Now that's different if corruption occurred after the investment was lawfully made and then furthering into the investment, some illegality did occur. That in those cases, we can talk about this more in the panel, in those types of cases, it's not a jurisdictional concern so much as one of admissibility. The practical consideration taken into account is whether or not parties raise the issue of corruption in arbitration. I think the considerations are rather different. In an investment arbitration context, investment arbitrations are generally speaking more public than private commercial arbitrations are. Investment arbitrations always will involve a state party. And generally speaking, it is the state raising this defense. So in a public sphere, the state essentially saying, oh, this investor procured this investment through corruption, is essentially pointing the finger at the state itself. This raises issues in the public regarding how the government is acting. This also raises issues regarding politicians. You cannot be pointing fingers at others in your party or even prior parties, and maybe you want to point fingers at prior parties or prior governments regarding the corrupt acts of those public officials. These type of defenses can also give rise then to investigations internally within the state. So whether or not a state wants to raise the defense of corruption becomes a strategic issue and a practical issue because the public nature of investment arbitration versus in the commercial context, which is more confidential generally speaking, and so parties can more readily decide to raise those defenses if they're not implicating themselves in the corruption. Because again, unlike the investment arbitration context, it could have been that only one of the parties was engaged in some form of corruption and not both of the parties that are party to the dispute. So that's a consideration that should be taken into account, and in fact is taken into account with governments when you're in the investment arbitration phase versus with private parties when you're doing commercial arbitration.
The panel we have here, I haven't asked them this before, so I'm as much interested as anybody in the room, if anybody's interested, and that is to see how much of a winning or losing of the case corruption allegations actually, how much of a difference they make. In other words, corruption is often very glamorous in terms of an allegation, and it focuses everyone's attention. But is it something which actually then gets established, the corruption gets established so that the claim falls away, or is it more often, in the panel's experience, made but not ultimately substantiated? So any thoughts there on experience or reading of the awards or whatever you have?
In one of my experiences, that when it is actually alleged as against the investor, that is actually a red flag for the tribunal, so it makes it much more difficult on the investor side to argue your case, because you're sort of tainted with a criminal allegation against your client, and it is a hurdle that you need to go over, especially if you are representing oligarch parties and people who otherwise have been, are business individuals. And so I think that on the investor side, it can be actually a very difficult hurdle to go over strategically. That's perhaps not the same question on the state side, and maybe someone else can comment on the.
But I just had something on the investment arbitration side of things. When I act for investors, the great concern one has as the lawyer, he obviously doesn't know the facts other than the facts as they are revealed to you through the documents or through witnesses, is that the state has some dramatic evidence of corruption which your client is not telling you about. And you then get into a strange dance with your client as to trying to find out exactly what has happened. So it can change the dynamics of a case in a somewhat mysterious and unquantifiable way. But Mark and Imad, do you have any thoughts about how much of a difference it really makes to the result of a case, the allegation, as just the making of the allegation?
I would say over the past decade or more, there's been a marked change in the trend of how tribunals deal with allegations about corruption. So it used to be that there needed to be very credible, concrete evidence, and it was treated as something that was a very serious allegation of essentially criminal activity. And so you better meet something that looks more like a criminal burden of proof in order to demonstrate this. You move on about 10 years, and these days tribunals are much more willing to look at red flags, indicia of corruption, a large payment to some third party in the jurisdiction whose services are clouded in uncertainty, and then the claimant is unable to explain to the tribunal in a credible way what that money was used for and what that person did. And they're willing then to draw inferences based on circumstantial evidence. So I think today it's probably easier for a state to defend based on corruption than it was, let's say, 10 years ago. But on the other hand, you see corruption being raised as a defense in so many investment treaty cases these days. So it's hard to know how that works out, whether statistically respondent states are more successful than they used to be. Certainly they raise it more often, but I'd say it's also easier, generally speaking, for them to defend based on those allegations.
So we'll turn to Khurram in just 27 seconds. In the 26 seconds left, Imad, do you have any thoughts?
I would agree with what Mark is saying. It's becoming more of a strategic decision about whether or not you will allege it. I will say this, having worked for a number of states now, including Uzbekistan, where we would always investigate whether or not there's corruption. We would always do our due diligence to understand what happened with an investment. I think it's an important aspect to at least conduct the due diligence, whether or not you allege it. I think we would actually, in most Uzbek cases, we do see the allegation. However, it can also render a hostile word against you if you prove it. And I think you can lose credibility as counsel before the arbitrators if you keep alleging it without being able to substantiate it.
So there's something we'll come back to after Khurram, but there's a general issue, which is the different standards that lawyers around the world apply to when they allege or don't allege corruption. So there are certain historical legacies which mean that lawyers in certain places are very willing to allege fraud or corruption or bribery. Lawyers in other places are much less willing, and it's an interesting topic which we'll return to after Khurram tells us what happens when an issue of corruption is raised in front of a tribunal. How do they deal with it, what standards they apply, and the like?
Sure, thanks, Paul. Let me start by a quote from the Himpurna California Energy decision. The members of the arbitral tribunal do not live in an ivory tower. The arbitrators believe that cronyism and other forms of abuse of public trust do indeed exist in many areas of the world. But such grave accusations must be proven. Rumors and innuendo will not do. Nor obviously may a conviction that some foreign investors have been unscrupulous justify the arbitrary designation of a particular investor as a scapegoat. So I think this sets out the broad context of corruption in arbitration. And what I'd like to do is just run through some concepts that I think we're all familiar with, and then see if I can test our intuitions once we introduce corruption into the mix. So first, I'll start with sua sponte. In other words, what happens when, in an arbitration, neither party has raised any allegations of wrongdoing, but the evidence, based on the evidence, the tribunal decides that it wants to investigate the matter further of its own accord. Now, the short answer is that this does happen often. Tribunals do look into this. But there's some guideposts that I think we need to be careful of, and I'm sure my colleagues in the panel have something to say about this. On the one end of the spectrum, an overzealous or perhaps ambitious tribunal could investigate allegations of corruption or perhaps evidence of corruption and issue an award that would be challenged at the enforcement level, and there would be a risk of the award being set aside for reasons of exceeding the scope of the arbitration submission. The other side of it is that if a tribunal is disinclined to look at such issues and decides to ignore prima facie or patent issues of corruption, for that reason as well, an award could be threatened at the enforcement stage before national courts that might want to look into the matter. So I think it's a bit of a tricky thing for a tribunal to get right, and it is something that there's been quite a bit of commentary on in the last 5 or 7 years. Next concept that we often come across is the burden of proof. Now, the default setting here, of course, is for commercial, contractual types of disputes. Each party has a burden of proving the facts in support of its claims or that stick out. One is that tribunals often, when it comes to corruption allegations, are not in a great position to fish out or ascertain the relevant and material facts. And then the related point is a tribunal lacks the subpoena or enforcement powers that a national court does. So for those reasons, some folks would say that at the burden of proof level, that needs to be shifted to the accused party. Having said that, on balance, most practitioners would consider that too radical a departure and would like to remain with status quo on that. So the burden of proof typically does not shift to the other side. Now, what about the standard of proof? So again, the starting point typically is a standard of preponderance of the evidence or balance of probabilities. When it comes to corruption, tribunals often look at a clear and convincing standard, which is somewhat higher, and they use that as a lens to examine the issues. And here again, there are commentators who think that is not sufficient, and there has been talk of a criminal standard, so that is to say, a beyond reasonable doubt standard. This is problematic for a number of reasons, two in particular. First, the tribunal is not handing down any criminal sanction, so it need not be concerned in the same way and cautious in the same way that a state court might. And the second point is that a tribunal has a hard enough time dealing with allegations of corruption, which are difficult to discover and ascertain. If you were to change the standard and make it more difficult to investigate and rely on such evidence, that would play into the hands of the unscrupulous actors. So for those reasons, I think there's general consensus that the standard of proof needs to hover between the, let's say, balance of probabilities and clear and convincing evidence. And then finally, I just want to touch on admissibility. So we're aware that UNCITRAL and soft law provisions give a tribunal broad discretion to look at questions of admissibility, relevance, weight of the evidence that's been adduced. In recent years, and this is something that my panelists have also touched on, there's been a further look into circumstantial and indirect evidence. And then to take it a step further, red flags. So the red flags are something that appear in the FCPA and in many forms of provisions, and it's been much discussed, I'd say, over the last 5 years or so. But let me just mention 3 which are quite common and arise frequently. So one would be a history of corrupt activity. So this is the historical aspect of activity or conduct is usually quite relevant. Similarly, when you have accounting records that are not transparent, that is also problematic and scrutinized. And then the way in which payments are made, this opens up a number of subtopics, but let me just say that if we were to simply focus on the accounting side, the number of indicators or red flags are enough that we could debate that point for some time. I want to close by just saying that where I think we stand on this is that everyone agrees that the fight against corruption is very important. We just need to be a bit careful that that's weighed against the rights of the parties and the integrity of the fact-finding process of arbitration.
Obviously, the evidence that one looks at to establish or put forward an allegation of corruption varies significantly, and it is rare that one finds a witness who is going to reveal the heart of the deep corruption. More normally, one's looking at documents like a consultancy agreement, which covers, in fact, a series of bribes. And if I come back to my general question before, this does lead to the general divergence and approach that certain lawyers in different legal jurisdictions take to what they regard as the foundational materials which enable them to allege fraud. So most of us, I think, on this panel will have worked with lawyers from different backgrounds, different cultures, different professional obligations. Is this actually an issue in practice, that there is a divergence as to when lawyers are or are not willing to make an allegation of corruption depending upon the background norms that they have grown up with? Maybe Mark to start with, and if anybody wants to contribute.
Sure. When you talk about corruption, generally speaking, or illegality, which is a broader category, you're really looking at a spectrum anyway. And of course, in different jurisdictions with different legal cultures, different political cultures, you're going to have different appreciation for what rises to the level of corruption that should have such a severe consequence that a claimant is deprived of its claim, or a contract is voided, and so forth. So sure, I can certainly agree with the basic notion that there's a difference in appreciation in that regard.
I mean, I come at it largely from the perspective of the English lawyer, and we require historically written evidence which discloses a prima facie case of fraud, or in this case corruption. It's been watered down slightly, so what is now is reasonably credible material which establishes an arguable case of fraud. But it is something that English lawyers take quite seriously and do give real pause for thought before they allege it. And I just, when I've worked with for or against lawyers from different jurisdictions, they're much more willing to allege corruption on what I would regard as reasonably weak or flimsy evidence. So let's move on to a related topic, which is bringing in Stephen, who is looking at it from the expert witness perspective. Are there any things which an expert witness needs to take into account when there are corruption allegations, or there is the possibility of corruption in a factual matrix? So the expert witness approach.
Thanks, Paul. So, as Paul says, coming in from a slightly different perspective, I'm not a lawyer. Tend to see things more technically, and in the work that we do, we tend to let the arbitrators deal with the procedural or the legal issues. Trett has offices across the globe, and who were asked to talk about corruption, reached out to my colleagues and said, can you help me a bit here? And they all went, I'm not quite sure what you're talking about. If you're talking about obvious bias in acting as an expert witness, we can talk to you about that, but corruption itself is not something that we see. A good expert is important to the outcome of the case in terms of quantum a lot of time, or technical issues. And if an expert is known to be corrupt or biased, he has or she a short-lived career. But I wanted to look at it in terms of the impact perceived or otherwise in the jurisdiction where I currently work, and just give you an example of what we think is a knee-jerk reaction to the idea of corruption. Article 257 of the UAE Penal Code has been around since 1987, and it was originally applied only to court-appointed experts. And it said that if an expert, in giving his opinion, stated something that was contrary to the truth or knowingly a false interpretation, this was punishable by imprisonment, which is quite stark. In October 2016, it was amended. For some reason, no one really knows why it was amended, but it then was amended to apply to all experts, so that included party-appointed experts, and it was extended to arbitrators as well. But the big thing was the change in the wording, which, paraphrase, said that if you gave a report or a statement that was contrary to a duty of objectivity or integrity, you could be punished by imprisonment. Now, there's no definition in the penal code of objectivity or integrity, so therein lies a big problem. But talking about the Peru case, everyone thought, well, this is just going to be abused, and the first thing that a party who's on the or appears to be on the losing side is going to say is that someone is corrupt, and that stops the whole process. In the UAE, a criminal complaint always tends to get investigated, and the result of that investigation is that in the interim, the alleged offender has to either surrender their passport, and that's the soft option, so you can't go anywhere for 2 years, or you're imprisoned. And of course, what happened in October 2016 and onwards was that the amendment resulted in international arbitrators and experts having a reluctance to accept appointments related to the UAE jurisdiction. That caused delays in the whole commercial arbitration process. Experts wanted to be appointed by the tribunal or jointly instead of being party appointed, and proceedings were being conducted outside of the UAE, so outside of the seat of the arbitration. Of course, many leading law firms and arbitrators lobbied against this and just said it was ludicrous. So that law has been revised again in September 2018, so very quite recently, and it's almost back to its pre-2016 version, where it no longer applies to arbitrators, it just applies to experts, translators, or investigators who are appointed by a judicial or administrative authority, so it's back to the courts or the government. And it's changed back to if you make a statement that's contrary to the truth or knowingly false, so probably a bit easier to define in terms of the penal code. That revision is seen as being hugely important because at the same time the UAE was bringing up its arbitration law, and all of this is now more in line with international best practice. The parties are finding it easier now to find suitably qualified and willing candidates to be experts or arbitrators, and it kind of restores the UAE towards a position of being the seat of choice for regional arbitrations. A long story. I was interested to hear the Peru.
I don't know that those words, a long story.
Yeah. The main point of it was that a knee-jerk reaction to corruption could create so many other problems that commercial or investment arbitration is tainted by. instead of allowing the arbitral process to manage itself.
We know that corruption, of course, is not confined to the parties in the original dealings. Indeed, in recent months, a rather mysterious award was removed, annulled, challenged on the basis that the entire arbitral institution was fictitious, and so that there were purported tribunal members party to the perpetration of some terrible corrupt activity, and experts clearly and lawyers are equally open to corruption allegations against them as parties, although in practice it's mainly parties. We have one little topic to go, but I'm going to give a choice based on what I see in the room. We can spend 5 minutes dealing with questions, or 5 minutes dealing with our last topic. So does anybody have any questions? And if no one's got any questions, we'll move to our last topic. If you've got interesting questions, we'll take the questions. Corruption's always interesting. Looks like we can just...
No, there are questions.
Oh, sorry, there is. Okay, give it. Whoever wants to go.
Maybe someone's scratching their head, I don't know. I saw some movement in there. Yes.
Okay, well, actually, let's do our little final topic and give someone else a yet further opportunity to raise a question. It's just to wrap things up in terms of the end result. What happens if corruption is established? What is ultimately the result, and in particular the legal analysis? Because in particular, if one reads investment arbitration awards, but sometimes even commercial arbitration awards, one sees a distinction between admissibility and jurisdiction, objections. Sometimes we see a rejection of a claim on merits, in other words, the tribunal has jurisdiction over it, but it rejects it on the merits. So if I turn back to Imad and Mark to give us some very, very, very brief thoughts on that.
Sure, let me start the discussion by discussing jurisdiction versus admissibility, because the concept of admissibility doesn't exist in every single jurisdiction, but of course jurisdiction and those issues do exist. So of course jurisdiction refers to the power of the tribunal to hear any claim that may be brought forth, whereas admissibility, by a very fine distinction, it addresses not the jurisdiction of the tribunal, but whether it is proper for a tribunal to in fact hear a claim. So, very fine distinction that was sort of elucidated on in the Waste Management New Mexico case, but it does actually matter, and it comes into play with respect to corruption allegations. Very broadly speaking, because we have limited time, the rule essentially goes that if the corruption occurred in the making of an investment, then there is no jurisdiction for the reasons that I explained earlier. However, if the illegality or corruption occurs after the investment has already been made, then the issue is not about jurisdiction, but rather about admissibility. And whether it's jurisdiction or admissibility, then also has repercussions and legal consequences moving forward. If it's an issue of jurisdiction, and a tribunal is hearing a claim of corruption on jurisdiction and going to find a determination in respect of that, in the investment arbitration sphere at the very least, and with respect to exit arbitration, that issue of whether the tribunal made the right or wrong decision will in fact become an unknowable ground. So the weight accorded to that decision is much greater when you treat illegality and corruption as a jurisdictional concern, but not so much if you treat that as an admissibility concern, because jurisdiction plays a very important role when the annulment of exit orders are concerned. By a similar token, if you have an argument on jurisdiction, essentially, as the state is saying to the tribunal, you can hear no claims whatsoever. Well, again, strategically and practically speaking, the state should be careful, because if the state has counterclaims to make against the investor, it shouldn't make the argument on jurisdiction, because the consequence will be that the tribunal has no jurisdiction to hear any claims whatsoever, whether it be the claims or the counterclaims. However, if the argument is, and the position is, that the tribunal should hear it as the corruption argument, as an admissibility concern, and throw out the claims of the investor because they're inadmissible, then guess what? The tribunal still exists. It still has jurisdiction. Owing tribunal, please also hear my counterclaims because I have them now against the investor. So it becomes a strategic concern as well as a legal concern in terms of the consequence it has for the cases.
As an issue of merits. Now, I wouldn't say that it's entirely black and white, because you could easily conceive of scenarios in which activities happen during the making of the investment, the life of the investment, which could give rise to an issue of jurisdiction or admissibility. So just to cite one example, in the Fraport case, there was an allegation by the government of the Philippines that the German investor, through a series of shell companies, had exceeded the 40% cap on ownership of public companies. If you just use that as a fact pattern, you could imagine if an investor had 30% ownership in a public company, and during the course of the investment acquired another 15% and went over that cap, then suddenly you might have an issue which, even though it occurs during the life of the investment, looks something more like jurisdiction or admissibility, and might result in the forfeiture of the entire claim.
Emilie, any concluding thoughts in 30 seconds or less?
It's quite challenging. No, just a short comment on when the issues on the merits. One theory that now has been developed and has been accepted in at least one case is the theory of clean hands. And so it's the idea that it's an equity doctrine initially, but it's the idea that you cannot claim if you have yourself being involved in corrupt practices. And in fact, so in one case, which was the case of Al-Warak versus Indonesia, the claimant won his case for fair and equitable treatment, but because he wasn't coming clean and there were corruption allegations, some allegations of illegality, not just corruption, he could not recover damages. And that's quite interesting because it's done on the merit. That was based on the specific wording of that treaty in that case, but there is more and more support for this to become a sort of customary international law theory that could potentially now be invoked more broadly in investment treaty arbitration. So just that's an interesting development to bear in mind.
Khurram, any burning issues in 25 seconds or less? No one seems to listen to me at 30 seconds. Maybe 25 words or less.
Like a question from the audience.
Khurram, say something.
Sure. So we've been talking about genuine concerns of corruption. I think we should also bear in mind that corruption can be raised in a frivolous manner to slow down the arbitration process, and might result in adverse inferences. However, it would still serve the purposes of the party putting those forward. So just something to keep in mind. I see both Sherry looking very nervous about time and somebody with a raised hand. So you can battle it out between the two of you. Whoever wins, let us know.
Very short question. Corruption moves while the body of jurisprudence has been discussed on the panel so far seems to be developing its own way. For my apologies, you've touched upon this already in one way or another, but does corruption include the corruption of the process on the investor on the state side, where governance laxes may have resulted in that corruption? And if so, how is that addressed within the arbitral proceedings?
Who wants to have a go at that?
I'm happy to sort of address that subject to other people's comments as well. If I understand correctly, I think you're talking about sort of how the government aspect of corruption also works. I think it's a great question. I think it's one that people have struggled with for some time now, because inherently by nature in investment arbitration, corruption involves two parties. It's the investor, and it also involves the state that also has been corrupt. And yet, for a very long time, tribunals essentially were only quote-unquote punishing the investor by throwing out their claims or throwing out their cases. Well, in recent years, there has been even more talk about the fact that the state also needs to be reprimanded. And so in a recent case that I worked on for Uzbekistan, while the case was thrown out on the issue of corruption jurisdiction, the tribunal came back and ordered that Uzbekistan commit millions of dollars to anti-corruption efforts to the United Nations as a penalty for being party to the corruption. It's a topic that we can talk about for ages, but it is something that we're seeing develop more, that in investment arbitration, the role of the state and the consequence that paid by the state as well has to play a role. Otherwise, the investor will always be, they are a wrongdoer as well, but they're not the only wrongdoer in that situation.
Just briefly, there's a case, Alasdair versus Costa Rica. It was an interesting case because the investors in that scenario had invested in what turned out later to be a Ponzi scheme. And the tribunal had to wrestle with whether this was an illegal investment because the money was invested in something that was inherently illegal, or whether, as the claimants alleged, the state was to blame because it had failed to properly monitor and detect the fact that this enormous Ponzi scheme was taking place under its nose. In that case, the tribunal decided that the claim itself was illegal and that the fault lay with the claimants. I don't agree with the outcome of the decision, but it was an interesting case because it raises the question of which side should be attributed with the burden of the investment being determined to be illegal.
Great. Well, with that, I think we will draw our panel to a close. Thank you for your attention. Thank you all panel members. They'll be here if you have your interesting questions, comments, discussion about corruption. And I thank you all very much.